Good day, sir. I am Rico Hudiatan. This is my final examination in CLJ 400 section alpha. So number one is define evidence and explain its scope. So revised rules are evidence rule number 128 section 1. Evidence defined evidence is the main sanctioned by the rules. These rules of ascertaining in a judicial proceeding in truth, respecting a matter of fact. Revised rules are evidence rule 128 section 2 scope. The rules of evidence shall the same in all courts and in all trials and hearings except as otherwise provided by law and these rules. So what are the three kinds of evidence? Briefly explain. So the three kinds is number one is revised roles and evidence. Rule 130 section 1. Object as evidence. Object as evidence are those addressed to the sense of the court. Now, the second evidence is the revised rules of evidence 100 Rule 130 section 2. Documentary evidence. Documents as evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expressions offered as proof of their contents. So the last three kinds of evidence is the revised rules of evidence, Rule 130, Section 22. The testimony confined to personal knowledge, witness and testify only those facts which is or she knows of his or her personal knowledge that is which is are derived from his or her own perception. So the next is that distinguish corroborative evidence from cumulative evidence. So corroborative evidence is additional evidence of different kind of character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Cumulative evidence is additional evidence of the same kind and character tending to prove the same point. This is purely the accumulation or similar evidence that is derived from common sources. Next is what is the prima facie evidence. So prima facie evidence is evidence which is unexplained or uncontradicted. It is sufficient sustained in a judgment in favor of the issue it supports. So next is what is a dying declaration. Section 37, dying declaration. The declaration of a dying person made under the consciousness of any impending death may be derived in any case wherein his death it is a subject of inquiry as evidence of the cause and surrounding circumstances of such as death. So what about statement other the part of the res gesti? Section 44 Section 44 part of the res gesti is statements made by a person while a starting occurrence it is taking place of immediately prior of subsequently under the stress statement caused by a occurrence and respect to the circumstances thereof may be given in evidence res gesti. Next is what is the order of examination of individual witnesses. So section 4 order in the examination an individual witness, the order in which is the individual so A is direct examination of the proponent. So in the section 5 direct examination in an examination in chief in a witness by the party presenting him or her on the facts of relevant to the issue. And section 6 is cross examination. Its purpose and extent upon the determination of the direct examination. The witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and the truthfulness and freedom from the interest or bias of the reverse and to elicit informant facts bearing upon the issue. In section 7, redirect examination, it is purpose and extent. After the examination of the witness has been concluded, he or she may be examined by the party calling him or her to explain or supplement his or her answers given during the examination. In section 8, recross examination. Upon the conclusion of the redirect examination, the adverse party may be recross examine the witness or matter stated it is her redirect examination, and also such as other matters as may be allowed by the court in its discretion. So the next is briefly explain what is the judicial affidavit. So the judicial affidavit rule or JAR took effect on January 2013. A normal court proceeding will be take around 3 to 5 and even more years to be fully decided. By requiring the submission of written affidavits of witnesses through the JAR, the time of the concluding a court proceed will be shortened. The judge the seeks to be distinguish the ever-increasing caseload in the county brought about by the high number of cases felt the lengthy procedures observed. So, an offer of compromise in criminal cases is an implied admission of guilt. What are the two exceptions? So, the two exceptions is one in quasi-offenses or acts defined and penalized under Article 365 of the RPC. So, and number two is those allowed by law to be compromised. So, in order for evidence to be admissible, it must be relevant and competent when evidence relevant. When it's evidence competent. So, relevance under Rule 128 Section 4, evidence it is relevant if it is has a relation to the fact it issued to induce belief it is existence or non-existence. Role we gather than the are two components of relevance. The next is competence. In addition, relevance, admission evidence that must also be competent under the Rule 128 Section 3. Evidence is a competent if it is not excluded by the law or these rules. So what is the leading question when it is allowed? So in Section 10, leading and a misleading question, a question which is suggests to the witness and to answer which the examining party desires a leading question, it is not allowed. So A is on cross-examination, B is on preliminary matters, and the next is of an unwilling or hostile witness or etc. So the next is what is the misleading question? Misleading question is one is the assumes as true of fact not yet testified to by the witness or contrary to the what is he or she as previously stated. It is not allowed. So distinguish burden of proof from the burden evidence. Revised rules of evidence. Rule 131, Section 1, burden of proof and burden of evidence. Burden of proof is a duty of a party to present evidence of facts it is issue necessary to establish his or her claim for defense by the amount of evidence required by the law. So what is the standard of proof of necessary? So civil cases, revised rules of evidence, Rule 133, Section 1. Preponderance of evidence how determined in civil cases the party of having the burden of proof must establish he or her case by preponderance of evidence. The next is criminal cases. So criminal cases, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. So in administrative cases, briefly define it. So revised rules of evidence, Rule 133, Section 6. Substantial evidence in cases filed in before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence. So, define what are the public documents. So, public documents, revised rules of evidence, Rule 132, Section 19. Classes of documents for the purpose of their presentation in evidence. Documents are either public or private. The written official acts are records of the sovereign authority bodies are tribunals and public officers, Philippines or of a foreign country, be or documents acknowledged before a notary public except last will or testaments. So, how do you prove and present in court private documents? So, revised rules of evidence, Rule 132, Section 20, proof of private documents. Before any private document offered as authentic is received in evidence, its due execution and authenticity must be proved by any of the following means. The original document rule states that when we presenting a document and evidence, only the original is admissible. What are the four exceptions? So, Section 3, original document must be produced exception when the subject of inquiry is the contents of the document. No evidence shall be admissible other than original documents itself except in the following cases. So, when the original is the custody of under the control of the party against whom the evidence is offered and the latter fails to produce reasonable notice. So the last is when the original is a public record in the custody of a public officer or is recorded in a public office. So next is who can become a witness. Qualification of witnesses. Section 20. Witness is their qualification except as provided in the next succeeding section. All persons who can perceive and perceiving their own perceptions to others may be witnesses. And the last is when it is a extrajudicial confession sufficient to sustain a conviction. Section 3. Extrajudicial confession not sufficient ground for conviction and extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. So that's all, sir, and thank you.